Good day everyone, I'm Sheila May Mendoza from 2C4 and I will discuss to you the International Convention for the Protection of All Persons from Enforced Disappearance. This international convention is made for giving concerns and due obligation of the states to its peoples. It is promoting universal respect for and observe of human rights. Let's proceed to the preamble. The state parties for these conventions, considering the obligation of the states under the Charter of the United Nations to promote universal respect for and observance of human rights and fundamental freedoms. Having regards to the Universal Declaration of Human Rights, recalling the International Covenant on Economic, Social, and Cultural Rights, the International Covenant on Civil and Political Rights, and the other relevant international instruments in these fields of human rights, humanitarian law, and international criminal law. Also recalling the Declaration of the Protection of All Persons from Enforced Disappearance, adopted by the General Assembly of the United Nations in Resolution 47/133 of 18 December 1992. Aware of the extreme seriousness of enforced disappearance, which constitute a crime in a certain circumstances defined in international law, a crime against humanity. Determined to prevent enforced disappearance and to combat impunity for the crime of enforced disappearance, considering the right of any person to be subjected to enforce. Affirming the right of a victim to know the truth about the circumstances of an enforced disappearance and the fate of the disappeared persons, and the right to freedom to seek, receive, and impart information to this end. All using things have rights. It's either rights for human, rights for animals, rights for life, for education, and right to have freedom. But in the field of human rights, there is a humanitarian law and international criminal law. Humanitarian law means a set of rules which seek the humanitarian reasons to limit the effects of armed conflicts, while international criminal law means a body of public. Article 1. No one shall be subjected to enforced disappearance. No exceptional circumstances whatsoever, whether a state of war or a threat of war, international political instability, or any other public emergency, may be invoked as a justification for enforced disappearance. Article 1 says that because international convention is to protect people and war or a threat is a kind of enforced disappearance which is not allowed. Article 2. For the purposes for this convention, enforced disappearance is considered to be the arrest, detention, abduction, or any other form of deprivation of liberty by agents of the state or by person or a group of persons acting with the authorization, support, or acquiescence of the state, followed by a refusal to acknowledge the deprivation of liberty or by concealment of the fate or whereabouts of the disappeared persons, which place such as a persons outside protection of the law. Sa Article 2, sinasabi na labag sa karapatan ng tao tulad ng deprivation of liberty, agents or the state ang pag-agaw sa kayaan ng tao o halimbawa na ang isang teritoryo. Pag-agaw ng hindi alam ng kinauukulan. Article 3. Each state party shall take appropriate measures to investigate act defines in Article 2 committed by a persons or a group of persons acting without the authorization, support, or acquiescence of the state and to bring those responsible to justice. Article 4. Each state party shall take necessary measures to ensure that enforced disappearance constitute an offense under its criminal law. Article 5. The widespread or systematic practice of enforced disappearance constitutes a crime against humanity as defined in applicable international law and shall attract the consequences provided for under such applicable international law. Article 6. Each state party shall take necessary measures to hold criminally responsible at least a person who commits, orders, solicits, or induces the commission of, attempts to commit, and accomplishes to or participates in enforced disappearance. A superior who knew or consciously disregarded information which clearly indicated that subordinates under his or her effective authority and control were committing or about to commit a crime or enforced disappearance. Exercise effective responsibility for the control over activities which were concerned with the crime or enforced disappearance. Failed to take all necessary, reasonable measures with his or her power to prevent or to repress the commission of enforced disappearance, or to submit the matter to competent authorities for investigation and prosecution. Above is without prejudice to the higher standards of responsibility applicable under relevant international law to a military commander or to a person effectively acting as a military commander. No order or instruction for any public authority, civilian, military, or other, may be invoked to justify an offense of enforced disappearance. Article 7. Each party shall make the offenses of enforced disappearance punishable by appropriate penalties which take into account in its extreme seriousness. Each party shall may establish mitigating circumstances, in particular for a person who, having been implicated in the commission of an enforced disappearance, effectively contribute to bringing the disappeared persons forward alive or make it possible to clarify cases of enforced disappearance or to identify the perpetrators of an enforced disappearance, without prejudice to other criminal procedure, aggravating circumstances, in particular in the event of the death of the disappeared person or the commission of an enforced disappearance in respect of pregnant women, minors, persons with disabilities, or other particularly vulnerable persons. We, as a human being, these protocols, rules, violations, or law is a part of our existing to the peaceful and a fair community. We all this and apply the humanitarian law. Thank you.
Article 8 provides the necessary measures and limitations for the criminal proceedings in cases of enforced disappearance. Article 9 states who should have jurisdiction over the cases of enforced disappearance. Article 10 states that after the examination of information available, a warrant can be made available and any state party where the suspected individual is present shall take him or her into custody or take such legal measures. Article 11 states that if the suspected individual is found in the state, they should submit the case to competent authorities for the purpose of prosecution. Article 12 states that any individual who alleges that a person has been subjected to enforced disappearance has the right to report it to competent authorities who shall examine the allegations promptly, impartially, and, where necessary, without delay, and when a reasonable ground is made, shall conduct investigation even if there is no formal complaint. The state party should prevent and sanction acts that would hinder the investigation. Article 13 provides that the offense of enforced disappearance shall not be regarded as a political offense or as an offense inspired by political motives for the purpose of extradition between state parties, and it states all the necessary measures and procedures to deal with it. Article 14 states that state parties shall afford mutual legal assistance in connection with criminal proceedings, including the supply of all evidence at their disposal. Such legal assistance shall be subjected to the condition provided for domestic law of the requested state party or by applicable treaties for legal assistance, including the grounds wherein a state may refuse to grant mutual legal assistance or make it subject to conditions.
Article 15. State parties shall cooperate with each other and shall afford one another the greatest measure of mutual assistance with a view to assisting victims of enforced disappearance and in searching for, locating, and releasing disappeared persons, and in the event of death, in exhuming and identifying them and returning the remains. So, in this article, state parties shall cooperate with each other to assist those victims of the enforced disappearance or those persons deprived of liberty or abducted and disappeared against his or her will. So, they must search and locate those victims, and if they're still alive, they must return to their relatives, and if they are dead, they must at least dig out their remains and return them. Article 16. No state party shall expel, return, surrender, or extradite a person to another state where there are substantial grounds for believing that he or she will be in danger of being subjected to enforced disappearance. For the purpose of determining whether there are such grounds, the competent authority shall take into account all relevant considerations, including, where applicable, the existence in the state concerned of a consistent pattern of gross, flagrant, or mass violations of human rights, or of serious violation of international humanitarian law. So here in Article 16, it says that a state shall not return any other person to another state where there are any substantial grounds for believing that he or she will be the subject for enforced disappearance. Enforced disappearance is the making the person disappear against his or her will. So, any other person shall not be returned to another state where there are grounds for being subjected to enforced disappearance. So, the state shall be taken into consideration whether they commit any violations of humanitarian law or any violation of human rights, so that they can determine if there is.
Article 17. 1. No one shall be held in secret detention without prejudice to the international obligations of the state party with regards to the deprivation of liberty, which state party shall, in its legislation, establish the conditions under which orders of deprivation of liberty may be given, indicate those authorities authorized to order the deprivation of liberty, guarantee that any person deprived of liberty shall be held solely in officially recognized and supervised places of deprivation of liberty. So, this article, it is said that no one shall be held in secret detention. No one shall be held deprived of their liberty. So, with regards to the deprivation of liberty, they must establish the conditions under which the deprivation of liberty is ordered, and those authorities that are authorized to order the deprivation of liberty
Guarantee that any person deprived of liberty shall be authorized to communicate with and be visited by his or her family, counsel, or any other person of his or her choice, subject only to the conditions established by law, or if he or she is a foreigner, to communicate with his or her consular authorities in accordance to the applicable international law. So, if any person is deprived of liberty, he or she is authorized to communicate with his family, relatives, and counsel, or any other person he or she chose. So, if he or she is a foreigner, then he must communicate with his counsel. Guarantee that any person deprived of liberty, or in the case of a suspected enforced disappearance, since the person deprived of liberty is not able to exercise this right, any person with a legitimate interest, such as relatives of the person deprived of liberty, their representatives, or their counsel, shall in all circumstances be entitled to take proceedings before a court in order that the court may decide without delay of the lawfulness of the deprivation of liberty and order the person's release if such deprivation of liberty is not lawful. So, if it is guaranteed, Article 18, subject to Article 19 and 20, each state party shall guarantee to any person with a legitimate interest in this information, such as relatives of the person deprived of liberty, the representatives of or their counsel, access to at least the following information. So, the state party shall guarantee any person, such as relatives, to at least access information regarding the person deprived of liberty. The authority that ordered the deprivation of liberty, the date, time, and place where the person was deprived of liberty and admitted to the place of deprivation of liberty, the authority responsible for supervising the deprivation of liberty, the whereabouts of the person deprived of liberty, including in the event of a transfer to another place or deprivation of liberty, the destination and the authority responsible for the transfer, the date, time, and place of release, elements relating to the state of health of the person deprived of liberty. In the event of death during deprivation of liberty, the circumstances and cause of death and the destination of the remains. Appropriate measures shall be taken where necessary to protect the person referred to in paragraph 1 of this article, or those deprived of liberty, as well as persons participating in the investigation, from any ill treatment, intimidation, or sanction as the result of the search for information concerning a person deprived of liberty. So, appropriate measures shall be taken to those persons that has relation with the investigation or the person deprived of liberty. Article 19. Personal information including medical and genetic data which is collected and or transmitted within the framework of the search for the disappeared person shall not be used or made available for purposes other than the search for the disappeared person. This is without prejudice to the use of such information in criminal proceedings relating to an offense of enforced disappearance or the exercise of the right to obtain reparation. The collection, processing, use, and storage of personal information, including medical and genetic data, shall not infringe or have the effect of infringing the human rights, fundamental freedoms, or human dignity of an individual. So, personal information regarding the persons deprived of liberty, like their medical and genetic data, shall be used only for the search of those disappeared persons. It shall not be used or made available in any other purposes. Article 20. Only where a person is under the protection of the law and the deprivation of liberty is subject to judicial control may the right to information referred to in Article 18 be restricted. On an exceptional basis, where strictly necessary and were provided for by law, and if the transmission of the information would adversely affect the privacy or safety of the person, hinder a criminal investigation. Without prejudice to consideration of the lawfulness of the deprivation of a person's liberty, state party shall guarantee to the persons referred to in an Article 18, Paragraph 1, or the persons deprived of liberty the right to a prompt and effective judicial remedy as a means of obtaining without delay the information referred to in Article 18, Paragraph 1. This right to a remedy may not be used, suspended, or restricted in any circumstances. So, the information regarding the persons deprived of liberty is restricted when a person is under the protection of the law and if the deprivation of liberty is subject to judicial control. On an exceptional basis, where it is strictly necessary and provided by the law, that if the transmission of the information would adversely affect the privacy and safety of the person, it is going to hinder a criminal investigation. Article 21. Each state party shall take the necessary measures to ensure that persons deprived of liberty are released in a manner permitting reliable verification that they have actually been released. Each state party shall also take the necessary measures to assure the physical integrity of such persons and their ability to exercise fully their rights at the time of release without prejudice to any obligations to which such persons may be subject under national law. So, this states that state party shall take necessary measures to ensure that persons deprived from liberty are released in with a reliable verification that they are actually being released. So, they must assure that those persons can exercise fully their rights at the time of the release.
Hi sir, hi to C4. My name is Love A. Pajac of 2C4. I'm the reporter of Article 23 to Article 29. Article 23 said that each state party shall ensure the training of law enforcement personnel or civil or military, medical personnel or public official and other person who may be involved in the custody of treatment of any person deprived of liberty, includes the necessary education and information regarding the relevant provision of this convention in order to prevent the involvement of such official in enforced disappearances. Emphasize the importance of prevention and investigation in relation to enforced disappearances. Need to resolve cases of enforced disappearance and recognize. Paragraph 2 of Article 23. Each state party shall ensure that order of instruction prescribing, authorizing, or encouraging enforced disappearance are prohibited. Each state party shall guarantee that a person who refuses to obey such an order will not be punished. Paragraph 3. Each state party shall not take the necessary measures to ensure the person referred to in paragraph 1 of this article have reason to believe that enforced disappearance has occurred or is planned to the matter to their superiors and where necessary to the appropriate authorities or bodies vested with powers of review remedy. Article is Article 24, Paragraph 1. For the purposes of this convention, victim means the disappeared person and any individual who has suffered harm as the direct result of an enforced disappearance. Paragraph 2. Each victim has the right to know the truth regarding the circumstances, the enforced disappearance, the progress and result of the investigation, and the fate of the disappearance person. Each state party shall take appropriate measures in this regard. Paragraph 3. Each state party shall take all appropriate measures to search for, locate, and release disappeared person, and in the event of death, to locate, respect, and return their remains. Paragraph 4. Each state party shall ensure in this legal system that the victims of enforced disappearance have the right to obtain reparation and prompt, fair, and adequate compensation. Paragraph 5. The right to obtain reparation referred to paragraph 4 of this article covers materials and moral damage and who appropriate other forms of reparation such as restitution, rehabilitation, satisfaction, including restoration of dignity and reputation. Guarantees of non-repetition. Paragraph 6. Without prejudice, the obligation to continue investigation until the fate of disappeared person has been clarified. Each state party shall take the appropriate step with regard to the legal situation of disappeared person whose fate has been clarified and that their relatives in fields such as social welfare, financial matters, family law, and property rights. Paragraph 7. Each state party shall not guarantee the right to form and participate freely in organization and association concerned the attempting to establish the circumstances of enforced disappearances and the fate of disappeared person and to assist victim of enforced disappearances. 25. Each state party shall take the necessary measure to prevent and punish under its criminal law the wrongful removal of children who are subjected to enforced disappearance, children whose father, mother, or legal guardian is subjected to enforced disappearance, or children born during the captivity of mother subjected to enforced disappearance. Paragraph 2. Paragraph 2. Each state party shall take the necessary measure to search and identify the children referred to in paragraph 1 of this article and return to their families of origin in accordance with legal procedures and applicable international agreement. Paragraph 3. Each state parties and shall assist one another in searching for, identifying, and locating the children referred in paragraph 1A of this article. Paragraph 4. Given the need to protect or best interests of children referred to in paragraph 1A of this article of their right to preserve or to have established their identity, including their nationality, name, and family, religion, and recognized by law, state party which recognized by a system of adoption or other form of placement of children shall have legal procedure in place to review the adoption or placement procedure and where appropriate to annul any adoption or placement of children that originated in first disappearance. Paragraph 5. In all cases, in particular in all matters relating to article, the best interest of the child shall be primary consideration, and a child who is capable of forming his or her own views shall have the right to express those views freely, the views of the child being given due weight in accordance with the age and maturity of the child. Article 26 is part 2 of Article 25. Okay. Paragraph 1 of Article 26. A committee of enforced disappearances, hereinafter referred to the committee, shall be established to carry out the function provided for under this convention. Paragraph 2. The members of the committee shall be elected by secret ballot from a list of persons nominated by state parties from among their nationals at biennial meetings of the state parties convened by the Secretary General of the United Nations for this purpose. Paragraph 4. The members of the committee shall be elected for a term of 4 years. They shall be eligible for re-election once. However, the term of 5 years of the members elected at the first election shall expire at the end of 2 years. Immediately after the first election, the names of these 5 members shall be chosen by a lot the chairman of the meeting referred in paragraph 2 of this article. Paragraph 5. If a member of the committee dies or resigns for any other reason, can no longer perform his or her committee duties, the state party will, which nominated him or shall, in accordance with the criteria set out in paragraph 1 of this article, appoint another candidate from among its national to serve out his or her term, subject to the approval of the majority of the state parties. Paragraph 6. The committee shall establish its own rules procedure. Paragraph 7. The Secretary General of the United Nations shall provide the committee with the necessary means, staff, and facilities for the effective performance of its function. The Secretary General of the United Nations shall convene the initial meeting of the committee. Paragraph 8. The members of the committee shall be entitled to the facilities, privileges, and immunities of experts on mission for the United Nations, as laid down in the relevant section of the Convention of the Privileges and Immunities of the United Nations. Paragraph 9. Each state party shall cooperate with the committee and assist its member in fulfillment of their mandate, to the extent of the committee function that the state party has accepted. 28. A conference of the state parties will take place on the earliest 4 years and at earliest 6 years following the entry into force of this convention that evaluate the functioning of the committee and decide in accordance with the conference of the state parties will take place at the earliest 4 years and the latest 6 years following the entry into force of this convention to evaluate the functioning of the committee and decide in accordance with Paragraph 1 of Article 20. In the framework of the competencies granted by this convention, the committee shall cooperate with all relevant organs, offices, and special agencies and the funds of United Nations, with the treaty bodies instituted by international instrument, with the special procedure of the United Nations, and with the relevant religion intergovernmental organization or bodies, as well as with all relevant state institutions, agencies, or offices working towards the protection of all persons against enforcement disappearances. Paragraph 2. As it discharges mandate, the committee shall consult other treaty bodies instituted by relevant international human rights instrument, in particular the Human Rights Committee institute the International Covenant of Civil and Political Rights, with a view of ensuring the consistency of their respective observation and recommendation. Next article, paragraph 1 of Article 29. Each state party shall submit the committee through the Secretary General of the United Nations a report of measures taken to give effect to its obligation under this convention within 2 years after the entry into force of this convention for the state party concerned. Each report shall be considered by the committee, which shall issue such comment, observation, or recommendation as it may deem appropriate. Paragraph 4. The committee may also request the state parties to provide additional information on the implementation of this convention.
Hello everyone, a pleasant day to all of you. I am Hernandez, Joyce G from BS Criminology 2C4. So today I am going to continue the topic about international conventions for the protection of all persons from enforced disappearance from Article 30 to Article 36. So let's start with Article 30. It says that a request that a disappeared person should be sought and found may be submitted to the committee as a matter of urgency by relatives of the disappeared person or their legal representatives, their counsel, or any person authorized by them, as well as by any other persons having a legitimate interest. So, in this statement, yung disappeared person daw po is, pag nag-request sila, so, kailangan na may submit ito sa committee. As a matter of urgency naman, pwede pong yung relatives of the disappeared person ang magpasa, o kaya yung legal representatives, yung counsel or authorized na person na kilala nila, and also yung person na may legitimate interest na yung kabutihan lang ang gusto para maipasa yung request ng disappeared person. So, second is that if the committee considers that a request for urgent action submitted in pursuance of paragraph 1 of this article. So, in this statement, makakonsider lang nung committee yung request ng disappeared person under nitong mga paragraph. First paragraph is not manifestly unfounded. Ibig sabihin, wala pong pinagbabatayan yung request nila. Pangalawa, does not constitute an abuse of the right of submission of such request. So, wala silang tinatapakan na right ng ibang tao para lang maipasa nila yung request nila sa committee. Third paragraph, has already been duly presented to the competent bodies of the state party concerned, such as those authorized to undertake investigations, which where such a possibility exists. So, yung submission or yung request na gusto nila ipasa sa committee is naimbestigahan na po yun. Dapat ding na-present na sa bodies of the state party. Kumbaga is, po siya, salang-sala na bago dapat siya ipasa sa committee. And the fourth is not incompatible with the provisions of this convention. Hindi daw siya, dapat daw is hindi incompatible, kundi compatible. Kung halimbawa, magpapasa ka ng request sa committee, dapat is yung request mo is, may tawag din, may po siya, may connection dun sa gusto mong makuhang request. And then last is, the same matter is not being examined under another procedure of international investigation or settlement of the same nature. It shall request the state party concerned to provide it with information on the situation of the person sought within a time limit set by the committee. So, dito po, dapat hindi daw siya in-examine ng ibang procedure. Kumbaga is, kung yung, yung request na ipapasa sa committee is, iisa lang po yung pwedeng mag-examine. Hindi na po siya pwedeng dalhin kung saan-saan. Tapos, ito po ay may binibigay na limitation or oras yung committee para maipasa mo siya ng ganong time or panahon. Second paragraph is, the committee shall consider a communication inadmissible where the communication is anonymous, the communication constitute an abuse of the right submission of such communication or is incompatible with the provisions of this convention. Next is, the same matter is being examined under another procedure of international investigation or settlement of the same nature, or where, if the committee considers that the communication matters meets the requirements set out in paragraph 2 of this article, it shall transmit the communication to the state party concerned, requesting it to provide observations and comments within a time limit set by the committee. At any time after the receipt of a communication and before a determination on the merits has been reached, the committee may transmit to the state party concerned for its urgent consideration a request that the state party will take such interim measures as may be necessary to avoid possible irreparable damage to the victims of the alleged violation. So, the last paragraph of the Article 31 is, the committee shall hold closed meetings when examining communications under the present article. It shall inform the author of a communication of the responses provided by the state party concerned. When the committee decides to finalize the procedure, it shall communicate its views to the state party and to the author of the communication. So, magko-close din po yung committee ng meeting dahil mag-i-examine sila ng communications na under ng present article. Tapos, i-inform na lang din po nila yung author ng communication kapag yung state party ay may concern na. And also, kapag ang committee ay nag-decide ng finalized procedure, makikipag-communicate na po sila doon sa state party and doon also sa author ng communication. Continuing the Article 32, it says that a state party to this convention may at any time declare that it recognizes the competence of the committee to receive and consider communication in which a state party claims that another state party is not fulfilling its obligation under this convention. So, yung state party daw po is magde-declare sila ng competence dun sa committee para ma-receive and ma-consider yung communication nila na yung ibang state party is hindi po nagpo-fulfill ng obligations and doon sa convention. And the committee should not receive communications concerning a state party which has not made such a declaration, nor communications from a state party which has not made such a declaration. So, yung committee naman po is, hindi po sila magre-receive ng communications concerned dun sa state party na gustong mag-declare ng communication sa committee. So, hindi nila tatanggapin yung communication ng state party kapag hindi po ito nag-undergo ng declaration. And also, yung communication ng state party is hindi din po nila tatanggapin kapag hindi sila nag-undergo sa declaration. So, Article 33, if the committee receives reliable information indicating that a state party is seriously violating the provisions of this convention, it may, or after consultation which the state party concerned, request one or more of its member to undertake a visit and report back to it without delay. So, kapag naka-receive daw po ng balita yung committee na hindi daw po nag-violate daw po yung state party doon sa convention, ay ang gagawin nila is bibisitahin nila yung state party para po ma-undertake sila or ma-report sila na hindi sila gumagawa ng tama and also without a delay. So, Article 33, Paragraph 2, the committee shall notify the state party concerned in writing of its intention to organize a visit, indicating the composition of the delegation and purpose of the visit. The state party should answer the committee within a reasonable time. So, yun na nga po, na bumisita na yung committee doon sa state party. So, ang gagawin ng state party is need nilang sabihin yung totoo, yung reliable sources, kasi po binisita na sila ng committee para sabihin nila lamang yung totoo. And then, upon a substantiated request by the state party, the committee may decide to postpone or cancel its visit. So, about naman doon sa state party na request, substantially, pwede din pong ma-postpone yung or ma-cancel yung pag-visit ng committee doon sa state party. And lastly, if the state party agrees to the visit, the committee and the state party concerned shall work together to define the modalities of the visit, and the state party shall provide the committee with all the facilities needed for the successful completion of the visit. And 5, following its visit, the committee shall communicate to the state party concerned its observations and recommendations. So, pag natuloy po yung pag-visit ng committee dun sa state party, lahat po ng kailangan gawin ng state party is paghandaan or i-prepare po lahat yung facilities na kailangan gamitin dun sa meeting area, and also kailangan din pong ma-obserbahan and yung recommendations doon sa meeting. Article 34 says, if the committee receives information which appears to it to contain well-founded indications that enforced disappearance is being practiced on a widespread of systematic basis in the territory under the jurisdiction of a state party, it may, after seeking from the state party concerned all relevant information on the situation, urgently bring the matter to the attention of General Assembly of the United Nations through the Secretary General of the United Nations. So, kapag nakatanggap daw po yung committee ng information na yung enforced disappearance is napapractice under the state party, which is under the territory of the state party, tatawagan din daw po nila agad ng pansin yung General Assembly of the United Nations through the Secretary General of the United Nations para po mapag-usapan lahat iyon. So, Article 35 says that the committee should have competence solely in respect of enforced disappearance which commenced after the entry into force of this convention. Dapat po yung committee is magkakaroon ng respeto dun sa disappearances concerning doon po sa entry ng force ng convention. So, second paragraph, if a state becomes a party to this convention after its entry into force, the obligations of that state versus the committee shall relate only to enforced disappearance which commence after the entry into force of this convention for the state concerned. So, yung state po, bagay po naging party ng state, ng committee yung state. So, kailangan po nilang mag-join force para po dun sa convention. And also, para po ma-relate nila yung meeting or yung disappearances na pinag-uusapan nila. And lastly, Article 36, the committee shall submit an annual report on its activities under this convention to the state parties and to the General Assembly of the United Nations. Yun po, kailangan daw po nila mag-submit ng annual report after nila mag-join force para po makita or mabasa ng General Assembly ng United Nations yung kanilang report. And before an observation on state party is published in the annual report, the state party concerned shall be informed in advance and shall be given reasonable time to answer. This state party may request the publication of its comments or observations in the report. So, parang interview lang po, no? Meron din po siyang bibigyan din po siya ng oras para sagutin yung mga katanungan nung convention para dun sa state party. Yun po. So, this is my continuing topic about the from Article 30 to 36 of the topic International Convention for the Protection of All Persons from Enforced Disappearance. Thank you.
So, good afternoon. I will be reporting Article 38 to 45 of International Convention for the Protection of All Persons from Enforced Disappearance. So, Article 38, in first paragraph, this convention is open for signatures by all member states of the United Nations. So it means that in first paragraph, all member states of the United Nations are open for signatures. In second paragraph, this convention is subject to ratification by all member states of the United Nations. Instrument of ratification shall be deposited with the Secretary General of the United Nations. So, what do you mean about ratification? Ratification is an act or process of ratifying something, such as treaty or amendment. So, in Tagalog, ratification is yung pagpapatibay. So ratification should always held by the Secretary General of the United Nations. Just remember it, that ratification shall be deposited always with the Secretary General of the United Nations. In paragraph 3, this convention is open to accession by all member states of the United Nations. Accession shall be affected by the deposit of an instrument of accession with the Secretary General. So, what do we mean about accession? So, accession is an act or process by which someone rises to a position of honor or power. So, it means in paragraph number 3 that this convention is open for someone rises to a position of power or honor. That this accession shall be affected by the deposit of the Secretary General of the United Nations. So, ratification and accession shall always deposit in Secretary General of the United Nations. In Article 39, first paragraph, this convention shall enter in force on the 30th day after the date of deposit with the Secretary General of the United Nations of the 20th Instrument of Ratification or Accession. In paragraph number 2, for each state ratifying or acceding to this convention after the deposit of the 20th Instrument of Ratification or Convention or accession rather, this convention shall enter into force on the 30th day after the date of the deposit of that state instrument of ratification or accession. In paragraph 1 and paragraph 2, it states that after 20th instrument of ratification or accession, the deposit with the Secretary General, the convention shall enter or it will effect on the 30th day after the deposit of the Secretary General of the United States. So remember that after 20th instrument ratification or accession by the Secretary General, the convention with after 30 days of date after the deposit of the Secretary General, it will effect on that day. In Article 40, the Secretary General of the United Nations shall notify all state members of the United Nations and all states which have signed or acceded to his convention. So, in Article 40, the Secretary General shall inform all his members or all the member states of the United Nations and state to sign and agreed or accept the convention, which is discussed in Article 38 and Article 39, which is in Article 38 is the signatures, ratifications, and accession. Again, signatures is open for signatures by all member states of the United Nations, and the ratification is act or process of ratifying something such as treaty or amendment. So, and the accession is the act or process by which someone was to be a position of honor or power. Then, in Article 39 is the date of entry into force of this convention under Article 39 nga. So, the date is, remember the date is after the deposit of the 20th instrument of the ratification of or accession with the Secretary General, the convention shall enter in force or it will effect on the day of 30th day after the deposit of the Secretary General of the United Nations. The provision of this convention shall apply to all parts of federal state. So it means in Article 41, the provision of the convention should be applied in all parts of the United or of the federal states rather. It should be without any limitation or exemption that all provisions of the convention should apply to all federal states. In Article 42, paragraph 1, it states that any argument or controversy between two or more states that cannot be settled through negotiation, one of them can send a request for arbitration. So, what is arbitration? So, arbitration is a hearing and determination of a dispute case by a arbitrator. So, arbitrator is the one who sent the request of arbitration. So, after the arbitration of 6 months, yet the two parties didn't or unable to agree in the organization of the arbitration, one of them should be held or one of them should be referred to the dispute of the International Court of Justice. So, in Article 43, this convention is without prejudice. From the word prejudice, it means it's any injury or damage resulting from some judgment or action of another. So, it means that this convention is without, from the word without prejudice, so without injury or damage to the provision of the international humanitarian law. So, it includes the obligation of the high contracting parties to the 4 Geneva Convention of August 12, 1949 and also June 1977, which is the 2 additional protocol. Then, in order for you to visit in any places of detention in situation not covered by the international humanitarian law, you should have, or the state's party have to have an authorized or have a request to the International Committee of Red Cross for you in order to visit places that are not covered by the international humanitarian law. In Article 44, first paragraph, it states that the states or any states that are or who are joined on the convention has the power or can propose an amendment, but it will file on the Secretary General. Then the Secretary General has the responsible to propose the said amendment to another states of the convention. And also it indicates or the Secretary General will indicate whether they favor a conference of the states for voting upon the said proposal. Then, within 4 months of communication, it should at least one-third of the states are favor on the such conference. Then, after that, the Secretary General will take an action such as shall convene the conference under the auspices of the United Nations. So, in Article 44 section or paragraph 2, any amendment adopted by a majority of 2/3 of the state parties present and voting to the conference. So, the Secretary General should present the votings of the other states to the parties for acceptance that many of the states are in favor with the said amendment. In paragraph number 3, an amendment adopted in accordance with paragraph 1 of this article shall enter into force or it will take effect when 2/3 of the states parties of the convention have accepted the accordance with their respective constitutional process. So, when it comes to 2/3 of the states that approve the said amendment, the Secretary General should have an maybe authorized letter of an acceptance it will provide to all states that they will accept the new amendment. And in paragraph 4 of Article 44, when amendments enter into force, when we say force, it means is it took effect. They shall be binding on those state parties which have accepted them. Other states parties still being bound by the provision of this convention and any area. Article 45, first paragraph, this convention, of which the Arabic, Chinese, English, French, Russian, and Spanish texts are equally authentic, shall be deposited with the Secretary General of the United Nations. So, what do we mean about authentic? Authentic is made or done the same way as the original. So, therefore, this convention, of which the Arabic, English, Chinese, French, Russian, and Spanish texts are equally made and done the same way as the original. And also, it will deposit by or with the Secretary General of the United States. So, don't forget the Secretary General of the United States. So, in paragraph number 2, the Secretary General of the United Nations shall transmit certified copies of this convention to all states referred to in Article 38. So it said that the Secretary General of the United States should made or provide a copies of the convention and provide it to all states who sign and accept or agree on the convention.